join. Lang went over to help. It should have been Aspen.
Or Jody.
Are you live?
There we go.
Where's your camera? There it is.
Yeah, it looks like we've got everybody on. Mr. Gornala, can you hear me okay?
Yes, Your Honor.
I can't. Hang on a sec. Try that again. Can you hear me okay?
Yes, Your Honor.
And can you see Mr. Hyde as well as myself?
Yes, I can.
And you can see Prosecuting Attorney Tennell?
Yes, I can.
Okay, Mr. Hyde, you can see and hear everybody?
Yes, Your Honor. Well, I see Mr. Tennell, Mr. Gornala, and you. I don't see anyone else.
That's the way it's supposed to be.
Okay.
All right, we're going to go ahead and get started here. You'll see a pop-up at the bottom of your screen notifying that we are starting the record in this proceeding. We are here in case number 15 CRI 041, State of Ohio Plaintiff versus Eliot T. Gornala, defendant. This matter is before the court for initial appearance in bond sitting on the complaint filed March 9, 2015. The record should reflect that we are conducting this hearing by video conference link with the Ashland County Jail, where the defendant, Mr. Gornala, is located. Appearing on his behalf is Attorney Andrew Hyde, and representing the State of Ohio's Ashland County Prosecuting Attorney Christopher Tennell. Mr. Gornala, do you have any objection to conducting this hearing by video?
No, Your Honor.
Okay, thank you. And did you receive a copy of the complaint that was filed on March 9?
Yes, Your Honor.
Okay, Attorney Hyde, are you ready to proceed on the complaint?
Yes, Your Honor, we are. I can acknowledge receipt of the complaint. We would waive its reading, waive a reading of statutes alleged to be violated, as well as the possible penalties, and I would enter a not guilty plea on Mr. Gornala's behalf at this time.
Okay, the court will accept the plea of not guilty. I had attached to the hearing document to the hearing as an attachment document a waiver of preliminary hearing. So that could be downloaded at the jail. Mr. Hyde, it's my understanding you had an opportunity to discuss the right to a preliminary hearing with your client. Is that correct?
Yes, Your Honor, that's correct. We spoke the other day and again today as well. It's Mr. Gornala's desire to waive his right to a preliminary hearing. I can tell the court, based upon our conversations, I believe that waiver is knowingly, intelligently, and voluntarily being made.
Okay, Mr. Gornala, have you had an opportunity to discuss your right to a preliminary hearing with Attorney Hyde?
Yes, Your Honor, I have.
And do you understand the nature of that right following that discussion with Attorney Hyde?
Yes, Your Honor.
Is it your desire to waive that preliminary hearing?
Yes, Your Honor.
And you understand that this case will then be bound over to the Ashland County Grand Jury for further consideration upon the court's accepting that waiver?
Yes, Your Honor.
Okay. The court will accept the waiver of preliminary hearing and order the case bound over to the Ashland County Grand Jury for further consideration. Anything you'd like to state on behalf of your client with regard to bond, Attorney Hyde?
No, Your Honor, not at this time. Thank you.
Mr. Tennell?
Your Honor, in looking at the Rule 46C considerations with respect to C1, nature and circumstances of the crime, we can advise the court the allegation centers on this defendant secretly videotaping kindergarten students in a state of nudity. He did this using a pinpoint spy camera that was located in the bathroom of the kindergarten class under which he had control. There are approximately 63 videos discovered on his personal computer covering 25 students. He was the teacher and in custody and control of these children at the time, and they were well within his care, which he used to facilitate the offense. In addition to those 63 videos, I can advise the court that there are hundreds of images of child pornography that appeared to be downloaded from the internet. The defendant for all of these charges is facing significant prison time. By analogy, looking at seriousness factors at sentencing, we're dealing with young child victims. They're approximately 5 years old in that kindergarten range. The defendant abused a position of trust. His occupation facilitated the offense, as did the relationship, and he did this over a period of time, and cultivating in certain circumstances several videos of individual children that he then cataloged on his personal computer at home. As we stated, these are his students on his computer in his classroom's bathroom. So under those C2 weight of the evidence factors, the state's case is extremely strong against Mr. Gornala. As is the C3 factors with respect to the identity of this defendant, it's absolutely unquestioned, giving it even greater strength. I would put under the C4 factors that this court should also already be aware from the 14 CRI 179 case, the defendant has exhibited a significant substance abuse issue. So given the strength of the case, the amount of time the defendant is looking at, those trust issues that have been abused, as well as his own substance abuse issues, the state would request $500,000 cash.
Thank you, Mr. Tennell. Mr. Gornala, it's going to be the order of the court with regard to bond that you sign a personal recognizance bond. If you violate the conditions of the recognizance bond by failing to appear for any future court hearing, your violation of that recognizance bond would be a separate fourth-degree felony offense. In addition to that personal recognizance bond, I'm going to require a cash surety bond in the amount of $500,000. No 10%. Conditions of bond will include that you not leave the state of Ohio during the pendency of this case, that you appear for all future hearings in the case, that you keep the court informed of your current address and telephone number, or that you obey all laws of the state of Ohio and all orders of the court while out on bond. As a special condition, I'm going to, like I did in the other case, order that you not use, possess, or consume drugs or alcohol, and that you be subject to random drug and alcohol screening during the pendency of this case. I'm further going to order that you have no contact with any of the 25 victims identified in the complaint or their families, either directly or indirectly. That means not only no direct physical contact, but no texting, no email, no social media contact, no email, anything like that. Mr. Hyde, I have you here Monday at 11:30 for a hearing on the 16th. Mr. Tennell, do you anticipate this case going forward later this week?
No, sir.
You do not?
No, sir.
Okay, well then we'll look at the next month. How about Wednesday, April 15th at 8 o'clock, Mr. Hyde? Would you be available then?
I believe so, Your Honor. I have Stephen Clark for a jury trial that day, but we filed a motion in that case. I've not heard yet whether the trial will be moved, so I'll either be here or be available.
Okay, then we'll set this matter for a further appearance and possible arraignment on April 15, 2015 at 8 o'clock a.m. That'll be in courtroom number 1, unless there's other arrangements made for video arraignment. Anything else we need to address, Mr. Tennell?
Your Honor, if we could add to the conditions of bond a prohibition against any sort of computer equipment with or anything with internet connectivity, as well as just a general prohibition of no contact with minors.
Okay. What do we have in the way of family members for Mr. Gornal? Any immediate family that we need to be concerned about here?
No, Your Honor, there's a mother and father, no younger siblings or nieces or nephews.
Under the circumstances, I think those are reasonable requests. There will be further restrictions as conditions of bond, Mr. Gornal, that you have, in general, no contact with minor children during the pendency of this case, and that you not have any access to any device that may be connected to the internet, such as a computer, iPad, iPod, anything that might have social media access or other types of electronic access to the World Wide Web during the pendency of this case. Anything else, Mr. Tennell?
No, sir, thank you.
Anything else, Mr. Hyde?
No, Judge, thanks.
All right, then that will conclude this hearing. Court's in recess. Defendant's excused. Thank you.